Hey, good morning, everyone. Why don't we get started? Um uh, my name is Malcolm. I'm the Chief Operating Officer at IDfy, and thank you for taking out time to join us this morning. At IDfy, of course, we're building the trust stack for India and the world, and one of our platforms is Privy, which is, at least we believe, the leading privacy and data governance platform that helps with organizations embark on a privacy and data governance transformation. But the idea today is to explore on the back of the rules. Now, where do we go from here? Right, that's what we'll be exploring. It's our privilege today to have join us an esteemed panel. I think it covers both stalwarts who can explain what's really changed, and then we've got also, if I might say, privacy thought leaders who will explain to us what happens now, right? And that's what we want to explore. We've also had the privilege with collaborating all of our three panelists today. So I just request them to introduce themselves one by one, perhaps starting with you, Supratim.
Yeah, thank you. But before that, thank you so much for inviting me here, and thank you, ladies and gentlemen, for your collective time. Uh, the DPDP Rules is finally here, so it's an exciting time. About me, I've been doing this for about 17 plus years, so long wait for me. Uh, and have been fortunate to have advised on the legal side, domestic and international clients, a number of them. The government also took note and been fortunate to have advised and provided inputs in relation to some of the digital laws, including this act and the rules that you are observing. Also, the Digital India Act, if and when it sees the light of the day. So yeah, that's a bit about me. Over to you, Malcolm.
Maybe Dipti, if you don't mind going next, please.
Sure. So I'm Deepti Laxmeshwar, the Data Protection Officer for Axis Bank. I've been associated with Axis for the last 12 plus years. And prior to being appointed as the DPO, I have been leading projects around data. So data quality, deduping, and all regulatory projects. So I bring the regulatory lens, on this table. Yeah.
Shubhosree, maybe would request you.
Sure. I'm Shubhosree, Chief Data Analytics Officer for HSBC India and its cluster markets. I have been associated with DPDPA for almost 3.5 years now. This topic, implementation, operationalizations, execution considerations, and mapping to GDPR to see what we can leverage globally as well.
The purpose of this is, obviously the rules are out. We're not going to spend too much time on that. I'm sure they're going to be dissected to death, but we want to spend time on what happens next, right? As we all know, the clock is ticking. So that's what we'll try and explore. And at least from whatever we gather, this is now, if it wasn't, it is now a board and CEO agenda item. So if it is, then what happens next is really what we want to discuss in this time. So then I'm going to start with you. It's obvious, I guess, that this question is going to be addressed to you, but what has really changed? I think draft rule came out in Jan, final rules are here. Um, you know, is there anything that substantially changed? And of course, I know the view of the authorities are people should have already started by now. I think we've had our own chat about it. But what in your mind has changed? And your short summary of that would really be helpful to start this off.
Right. So I have a habit of this, scribbling my own notes. So maybe I'll just quickly read out from some rough notes. Okay. Before I talk about the changes, one important clarification is the date. Okay. Because it came out on 14th of November, many think that the start date is 14th. But if you carefully look at all the documents, it is 13th of November. We have taken a reclarification from the ministry. Please consider all dates to be 13th of November, and basically the relevant dates from there on. So it has come into effect on 13th of November 2025. Data protection board related provisions are triggered. 1 year down the line, 13th November 2026, all consent manager related provisions get triggered. And thereafter, all other provisions, which is most material for most of our organization, all compliance requirements, etc., that triggers on 13th of May 2027. Okay. Interestingly, Malcolm, I had a situation when GDPR came into effect. The night before, a gentleman came to my office and said that boss has sent me to you. Here is my privacy policy and terms of use. just can you make minimal changes? I will upload it tonight, and tomorrow morning onwards, we are GDPR compliant. I am, hoping that that should not happen with the DPDPA, now coming into play. What are the changes? Okay, I'll go maybe one by one, rule by rule, and keep talking about it, whether it is maybe minor or major. The first one is Rule 3. I think it's seemingly minor, but when you go to implement it, probably you will find there is some important deviation there. What it generally it talks about notice, okay, and it says that you should have itemized list of data that you are collecting. It also had that itemized description of goods and services should be provided. It's almost like a dual mapping. When you look at it from a mind map perspective, maybe it's like a dual layer. Now, the second itemized, which is for goods and services, has been replaced with specific. So you have to give specific description, but they have, thankfully removed itemized description of goods and services. So little bit of leeway, but just look at it a little carefully. Don't take too much liberty; it can backfire. Okay. Um, Rule 6 is the next one. I think it's a major one. Okay. Reasonable security safeguards. There was a baseline which was provided, and everyone thought that, okay, these are absolutely mandatory. Beyond that, you can do certain things. Okay. But some sort of language loosening has happened there. And wherever they have said you should be doing this, including blah, 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 instead of that, they've said such as so and so. So therefore, it's kind of indicative that, whatever data you're handling, etc., it will be probably commensurate to that. They've also at a couple of places added the phrase where applicable. So you kind of bring this into play wherever it is applicable. So that's, I think, a welcome change. Rule number 7 is next, which is a minor one. But depending on what has happened in the organization, which is data breach reporting related. Earlier, there was a item there, which is you have to give the location of the breach. Now that word location has been removed. Next one is Rule 8.3, super critical. I think this is new and major. Retention of data and logs for 1 year for certain governmental uses. Okay, so beyond the purpose that you can keep the data for, beyond any person requesting, please delete my data or deleting the app, the account, etc. For certain governmental purposes, of course, there is a list of governmental agencies and the purpose, etc., who can authorize. But you have to keep this for 1 more year. So this is a complex situation, Malcolm, because it's an interplay of what maybe your cybersecurity regulator has already been saying, what this law is saying, what a sector regulator would be saying. So you will have to accordingly walk your way through all of this and have a proper data retention strategy. Okay. Next one, I think, is Rule 8. This one is Rule 10. I think, again, a major one, which is a verifiable parental consent. Okay. Now, interesting fact is when you think of verifiable parental consent, there are 3 things to be done. 1, whether parent is above 18. 2, whether child is below 18. And 3, whether there's a parent-child relationship. The third one is the most difficult for a country like India because central level documents, state level, mofussil level, and all of that. The good part is somewhere they have loosened the language there to say that the gun is not on your head to go and do extreme amount of due diligence to figure out that whether it is a parent-child relationship. Okay. What they've said is if the parent has come, this is my child, here is my document, you prove identity, you prove age, it's good. Similarly, if the child is saying this is my parent, etc., it's a check from an identity and age perspective. So I think this is I would say, a welcome change because there was a lot of pressure. Unfortunately, this is not available for persons with disabilities because there you'll have to still go and check guardianship the way the law wants it. Next one is Rule 13, which is in relation to significant data fiduciaries. We are all aware these are players who are crunching large amount of data, important data, which has to be called out yet through a separate notification, who all are significant data fiduciaries. In the last version of the rules, we had seen that algorithmic accountability was slipped in, which is, maybe some things that you're doing with AI, you need to ensure that this is not coming in the way of the rights of the individuals under the law, etc. Now they have made it even broader. What the language says, and let me read it out for ease of understanding of everyone. It says significant data fiduciaries to observe due diligence to verify that technical measures, and this is new, technical measures including algorithmic software adopted are not likely to pose a risk to the rights of data principal, extremely onerous, very broad brushed. Okay. With the kind of playing that we are doing with AI, I think we have to be extremely careful, especially if we are a significant data fiduciary. Next point, major again, rule number 14.3, which is data principal rights. Now you have an upper cap of 90 days for grievance redressal. Earlier, this was missing, though I think 90 days is a good enough time period, but this upper cap now exists. And the last one is in the fourth schedule of Part B, related to Section 9.1 and 9.3, which is exceptions to handling of children's personal data. You are aware that in relation to child's data, you cannot track or monitor children, and you cannot do a targeted advertisement, etc. There are certain exceptions. One new exception has been brought in, that you are allowed to track a child, their real-time location of that child, provided this is for safety, protection, and security of the child. So that's a quick snapshot of all the changes, big and small.
Yep. No, thank you, Supratim. It was fairly elaborate. So in summary, is it fair to say that the spirit and the essence has stayed the same? There are some places where probably it's more specific. Some places, I think one or two places where it has been, you could say, perhaps more prescriptive in terms of how you go about it. Would you agree with that? Is that a fair view?
Absolutely. And Malcolm, you and I have done several sessions. We have been continuously telling that life will not magnanimously change. Don't expect
Perfect.
that a very new draft suddenly comes up, right? There's only tidbits which will change. We still believe that nothing that way significantly has changed, and you're
Perfect.
absolutely right.
No, super. So, Deepti, Shubhosree, I'm going to ask you, and maybe Deepti, starting with you first, now that the real sort of rules are there in front of you, and you've been already on the journey for, anywhere from 6 to 12 to 18 months, right? Uh, what does this change anything, or like we said, nothing much has changed? Maybe some things on the margins, some things to be more careful about. But love to hear from both of you. But Deepti, maybe starting with you, and then Shubhosree.
So yeah, honestly, as as Supratim has mentioned, so have the lawmakers mentioned over the past couple of years, I must say, that nothing much is going to change. The act is pretty simple to read, to understand, and it was not that we were expecting some great changes. If anything, this is just a milestone, and not a really real turning point. And any which ways, somewhere in September they did mention that the rules will come out somewhere before the winter parliament session. So
That's true.
it's just that you were still waiting, and it just popped up. But yeah, and nothing much changes, especially given the fact that whatever changes Supratim has mentioned right now, all of those are the finer changes which would have any which ways come at a later point in time. Otherwise, when you're talking about building and looking back at your systems, your privacy by design, the awareness, the cultural changes, all of those, there's been nothing, no change as such in whatever you were building over the past 12, 18 months. Yeah.
Super. Shubhosree, your take.
So for me, the way I look at it is nothing changes from law's perspective, but Supratim was very, very precise in pointing out incremental changes, if any, right? Particularly the broad brush around algorithmic software, and we leverage a whole lot of AI. That does worry me to a large extent. But what it has got us now from a global bank perspective is I would say, a date with a deadline.
Hmm.
So the deadline is here. It's a specific date from a full comprehensive compliance perspective, which obviously brings a certain level of urgency from operationalizing and moving away from pure privacy design phase to a comprehensive execution phase. So that urgency is what the new rule gazetting brought to us.
Got it. No, thank you. And I think therefore, as we've said, if you've started, great. Nothing much changes. If you haven't, I think it's time to. Uh, so maybe moving on, and let's maybe now go to the second part of our conversation, which is, for BFSI players and of the similar ilk. How do you think about, therefore now, where do you go and what the journey looks like, right? And so with them, I'll come back to you and say, obviously BFSI is sort of conventionally called regulated sectors, right? So how do you think the expectations are different? Do you think perhaps the rigor, the scrutiny will need to be different? I also understand you alluded to it. There are sectoral regulators, so Does this make it more complex? And maybe the other part to this is therefore, is there anything that BFSI players will need to do differently? What would be your take on that, Supratim?
So I think in the BFSI space, the news is good and bad. The good news is because the sector regulator has already been running with a stick for some time, especially regulators like RBI. Therefore we are kind of prepared, okay, or at least we think we are prepared. We'll have to see that how exactly the nuts and bolts have to be tightened. The not so good news is that there are multiple layers of the play in relation to data regulation, right? So one example I was giving is in relation to data retention. If you just look at the kind of data segregation that you'll have to do and the kind of retention period that you have to build in, is just mind blowing. So therefore, the sector is so critical. Your direct impact could be a monetary impact. Individual is impacted. It can hit the press badly, so it can become quite a bit of a mayhem. We have had situations in the past where certain data related transaction was happening, and the sector regulator said that I am giving you a softer blessing, but if anything hits the press, bad press, this approval, this softer approval is off. So you can clearly understand the tricky zone that we are in, and therefore there has to be double caution which has to be adopted. And I think the thumb rule, the main issue that I would again emphasize on is how do I look at the kind of data that are applicable here. If you look at it, some parts of Information Technology Act will still remain. Okay, you look at Section 72A, which is dealing with only personal data, that would still remain. It doesn't go away. 43A and sensitive personal data rules, those get removed right now when 18 months get over and the new law comes into play. DPDP Act is giving overarching principle, and there also they have created some confusion. In one provision you would have read that if there is a conflict between this provision and another law, then this law will prevail. Some people started thinking then if RBI is saying something, if it is conflicting, then I will follow DPDP Act. The answer is no. They have clarified softly in other closed door meetings that, listen, ordinarily we are expecting that you will read all the laws harmoniously. In case there is a conflict, of course, try to see if it can be resolved amicably. If not, we are very clear from our rules of statutory interpretation that a sector regulator, whatever they have said, that will prevail. So please don't go with the assumption that.
Yeah.
I think these are some of the tricky zones, but definitely much more trickier for this space.
Yeah. Just one more quick add-on and maybe quick response, Supratim, is, and some of this is also coming through in the chat, is do we expect sectoral regulators to provide sort of more clarifications, prescription, or now it is what you said, right? Looking at what they have and this and harmoniously deciding your way forward.
So I think, again, just amongst this group, we believe that the government is also working on some FAQs pertaining to this law. But our fear is that sometimes the FAQs create more confusion than clarity. Sector regulators, the expectation is they should be giving guidance, okay? And in the past, there have been between certain regulators, there has been a handshake that we will work cooperatively to see that we are not talking differently. But I think it would probably take some time for certain regulators. Some are more proactive, though. Guidances could be given, but you have to still remember that this is in itself a different legislation. They can refer to each other, but one regulator cannot start changing something which is already prescribed in this law, right? So that.
So maybe just some of the fine print may be clarified, but the spirit and the objective will remain the same.
Yeah, I think there was always a plan that they should be. Of course, we got delayed. That's why everything got derailed. But the idea for the DPDP Act always was that this will be the mother umbrella legislation. All the sectoral regulations should fit under it, right? Ideally, that was the thought process.
Correct. Okay, great. Shubhosree, I'll turn over to you. You've seen, as you mentioned in your introduction, you've seen the GDPR journey. Obviously, you belong to the global bank with full-fledged sort of operations in India. What do you think, not at a micro level, but what do you think is sort of fundamentally different in this case? And therefore, is your approach fundamentally different in India vis-a-vis, let's say, the global playbook?
Yeah. So, Malcolm, that's an interesting question, right? Because to a large extent, the entire organization is GDPR compliant. And what GDPR compliance already covers would be certain principles around be it consent, notice, purpose limitation, data minimization, data subject rights, maybe protection, impact assessment, certain customer data security safeguards, etc. Right? However, there is some very, very specific nuances that come across with DPDPA, where I'm sure most of the global organizations like us will be straddling a balanced boat of maintaining the global umbrella with local customization. So, very specifically, I'm going to call out a few areas of DPDPA, be it the consent language, notice format requirement. To us, the biggest departure from GDPR is absence of legitimate interest as a lawful basis. When it comes to DPDPA, any processing, storing of personal data is consent led, even if it is for providing for banks like us a banking service. That's a huge departure from GDPR. And as a result, the entire privacy by design, consent designing, and subsequent processing, all of that starts from that single premise that it is consent led. And then every other data processing, storage, subsequently minimization it starts from there, right? We had to actually go back to drawing board when we were implementing DPDPA to say, and there is a third angle, right? Third pillar is in maintaining an integrated architecture with consent managers, which will come as DPIs, and also the other DPIs, be it account aggregator, OSAN, various others in the economy. Again, departure from GDPR. So the considerations were as follows. Of course, the global umbrella, leverage what we can from our global umbrella, what we were already compliant with, bring in the local flavor with consent and then privacy by design, consent-led privacy by design, and integrate with local regulatory infrastructure. So it's a three-cornered, three-pillared approach. As you can see, two-thirds is India-led. So to a large degree, we went back to our drawing board.
No, that I think you summarized that at the end. You kind of had to go back and rethink this, but thank you for sharing that in detail. Shubhosree, appreciate it. Deepti, I think turning to you, your bank has obviously been in the public domain as an early mover in this space, and of course you are living and breathing what Supratim described, right? Implementing this in a bank, large bank. Um, two questions I think in terms of is this now a CEO board CXO agenda item one, and two, what might have been for the purpose of the benefit of our participants, right? What might have been some of the complexities that you've probably encountered and handled along the way in your journey till date?
Sure. So, I mean, answering your first bit, I mean, it was, at least with Access, it was always been a CXO agenda. It's always been a top-down approach right since the inception. That is where it has put us ahead at this point in time in terms of wanting to implement privacy. Having said that, when you talk about bank as large as ours, with systems, legacy systems going back to over 30 years now, the challenge that you're looking at today is our legacy systems, not only ours, even many other organizations whose systems were built way back. Privacy was never a part of those systems and platforms that were brought in. Okay, also having to have consent management, data minimization, because the thought process always was ensuring that the customer doesn't need to come back, so collect as much as possible so that tomorrow I really don't need to bother the customer. And whereas under the DPDP Act you're talking about data minimization. So that is one challenge when you're looking at it of moving your legacy systems. And also obviously you talk about privacy by design, but that is more from a perspective standpoint. So retrofitting designs is what you're taking care of there, but yeah, legacy systems is one. The other aspect that I look at is typically as long as you talk about data stopping at your bank's boundary, that's fine. But you're also talking about a larger ecosystem. Data moves out every single day. And with the DPDPA making it, putting the responsibility solely on the fiduciary, that becomes even more important, that you are responsible for the data that is even moving out into the ecosystem with your vendors. So tightening of vendor agreements, and moving the assessment lens, not only in terms of the purpose for which that vendor was hired, but also the volumes of data and the type of PII that is moving out to the vendors. Putting that lens when you're doing a risk assessment of those vendors, that's another challenge that usually larger organizations will face. And last but not the least, since you're talking about the Indian context, we as a society, we know that we have seen it on a daily basis, literal street vendors having your PAN and Aadhaar copies to serve their bhelpuris. Okay. Uh, to explain the importance of privacy, not only to your employees, to your frontline staff, to your vendors, but more importantly, to your data principals. What is it that you share? Where is it that you share? Only because you want things simpler, do not share things on WhatsApp. Because WhatsApp, how do you even purge data that you would have probably shared on WhatsApp to XYZ for a faster movement of your opening of your account? So while someone may very clearly say that this is more of we did it based on trust, it is a risky behavior, and that is something that awareness is going to take a very very long time, especially in a society like us. The cultural shift is more required at this point in time than any other design change, which is still in our
True.
hands. Yeah.
No, no, absolutely, Deepti. I think while you said, you put it rightly to say, while organizations might comply, I think there has to be a broader sensitization, which I think, the Indian public is also at times very, very swift on some of these things, right? We've seen it with other things like UPI and all that. So hopefully we see some of that here as well. Anyway, so moving on to the third segment now, and thank you again for sharing, Deepti, very candidly. Is now okay. So we've talked about rules are here, not much has changed. BFSI, of course, is complex, multiple challenges. I think we've spoken about global playbooks may need to be rewritten, and of course, I think we also heard in the case of Axis Bank, there are several things you need to iron out along the way. So now let's talk about sort of what does on-ground implementation look like. I think the date Supratim has very carefully clarified is November 13th and not November 14th. So,
Yeah.
so the clock is ticking as we all know. So let's start. Let me this segment start with you, Shubhosree. Um, I know you referred to it that you kind of have to rethink the playbook from the global playbook. I think Deepti talked about some of the challenges. So if you put the two together, what are some of the, if you can, to the extent you can share, what are some of the sort of practical, decisions, considerations you've had to make as you're beginning to operationalize this?
Absolutely. So the first and foremost is our consent-led architecture, including the language requirements and notice norms, right? So that entire consent-led architecture, the way we are taking consent, thinking consent, and starting from consent, in fact, created a consent data model to input for existing customers what consent we have in a structured manner would be the first thing that I would allude to. The second, and I think Supratim, you, Deepti, to some extent, you refer to it. Now, the journey we started on 18 months, which seems to be quite a tight deadline, is data minimization, data deletion, data retention, segregation of data between regulatory, cyber. Within cyber, you have to maintain log for a year. Regulatory data, of course, in alignment with RBI, PMLA, IT, the local Indian laws, we maintain what we call CRRS or customer record retention schedule. But now, system by system, we have to set deletion triggers post our minimum retention norms, right? And that is not easy. For a global organization like ours, where data traverses through networks, there is centralized hub and spoke. Data is kept in many, many places, many systems in a web of, I think, more than 3,000 plus applications. You can imagine what a size and scale of operation that would be. The other thing to think about is backups. Your disaster recovery, your backups, your BCP servers, when you are giving a notification to your data principle that I am about to delete this entire data from my system, it means it becomes completely untraceable and cannot ever be retrieved. So to the extent that you are comprehensively able to fulfill that obligation is something that we are designing for. And that's a massive exercise, honestly, between legitimate interest in GDPR versus what DPDPA requires us to do and the extent it requires us to go to. The third is, I think somebody wrote on that chat box about what do we do now? Immediately as it comes into effect, you have to think about a grievance redressal mechanism which is effective literally within the time permitted and permissible by the law. So how do you set that up? What's your escalation mechanism? How do you ensure that you know what has happened? How are you able to go back to your data principles to notify in case with a satisfactory redressal? 90 days is a long period of time, but hopefully even within that, with a satisfying uh, redressal of their grievances. What happens when someone says that, please delete my consent from all your systems? We're talking about all the 3,000 of those applications, right? How do you ensure that their data gets deleted? So this itself, from a design perspective, is a massive piece of work. So if you ask about my first, I would say what my priorities are, how we are getting organized. It is about what we can leverage globally, what we can fine tune locally, and wherever there's the largest gap, that's what we are starting with.
Thank you. Thank you, Shubhosree. Deepti, I'll come to you in a minute, but let me ask Supratim one of these questions in between that we had. Supratim, there is this 18-month timeline the law talks about. There was some article about it may get shortened and this and that. I think, uh, you know, and as we all know, right? I think we have on this call itself, a couple of organizations that have moved. There are others who are probably deciding to move, and probably there's still others who might still be waiting, right? So, what would be your advice? Is this because there is a sense that, oh, there's a lot of time, maybe we can start in 6 months. What would your advice be? And to some extent, is this timeline thing going to, are there going to be any more further milestones? Just clarifying a little bit was what was in the press a couple of days back.
Yeah, so I think as we go along, there would be constant, maybe surprises, if I may call it so, because we are actually building the parachute as we are falling. Okay, so it will be a work in progress from everyone's side. Okay, government side, organization side, all of that. I think we should keep that in mind and be cognizant. The GDPR and other such laws experience has shown us that even such mature jurisdictions and organizations, they faced immense amount of trouble, and they were not ready by the end of that deadline. Okay, most of them. And we should just be completely cognizant of that. I like actually what Ashok says, and we and I, whenever we are chatting, we kind of discuss this, that there's a stock problem and there's a flow problem. I think the way to look at it is that, okay, we will have to do data discovery, etc. That can continue at the back end. Uh, as a flow going forward here onwards, whatever business has to be done. For example, checking all your consent, notice, agreement clauses, all of those. I think that is one activity which should be also started in parallel. Okay, so that you hasten the process. You will always think that you've fallen short. Okay, even if you're going full steam, I think at the end of 18 months, you will still think that maybe you could have gone faster. So suggestion definitely is that do not delay. One other tip could be that, in parallel, also start the training exercise for the relevant people. I would say for the entire organization for sure, but at least for the privacy champions who are from each of your functions, HR, marketing, legal, etc. I love this author, Devdutt Patnaik, and he had come to one of our sessions. He said that, listen, culture is such a thing that it is not a pill that I give you, you have it tonight, tomorrow morning, you will get culture. So privacy culture, we have to build over time. Maybe these 18 months we should also use to properly build in that culture of privacy. And of course, the other work I've already told you, the stock and the flow problem should be also tackled. Thank you.
So your view is start yesterday. Is that fair to say?
Day before yesterday. You know how much we have been yelling from the, but it is, this is.
No, I think that was a little bit of a setup because the next question is straight to Deepti, who has started not day before yesterday, but several months back now. So
Yeah.
I assume based on this, Deepti, you look at it as a positive, I guess, that you started a few months back. But to the extent you can share, you've been on this journey for I think at least 6 months, if not 12. And to the extent you can share, what would be your, at least, did you think of this as multiple phases? And what were some of your, learnings, etc., to the extent you can share? All of these obviously would be helpful to our audience because they're probably going to start now. What you started probably a few months back, and Shubhosree started, of course, again a few months back.
Yeah, so I mean, honestly, given the fact that even if I started day before yesterday, 18 months still seems very short, if I may say so. And that is based on experience. And IDfy has been our partner in this journey, and your counterparts would tell you that the last year or so has been like 3 steps forward, 1 step backward. Because every time you try to, probably even as much as draft a, consent notice, I'll go back to the same point that I mentioned earlier. You're still talking to India and more importantly, Bharat. Okay. Whatever you want to put, while the act says it has to be simple and explicit and, so on and so forth, it has to be something that is understandable by your data principal, what they are consenting to. So even drafting the notice artifact has been a challenge. Not make ensuring that the customer experience is seamless, not ensuring that there's not a lot of customer fatigue, and if I may say so, ensuring frictionless customer experience, but at the same time frictionless business operations. Because while you're already wanting to catch up speed because your counterparts would any which ways be dishing out accounts faster than you. You really want to take care of those stats, and more importantly, you want your people or rather your employees to not look at it as another compliance tick box, and that would mean bringing in all of these changes at the very outset. So privacy by design. So all of this honestly has taken so much time, and there is so much more to do. That 18 months, even as I look at it, seems so short, especially when you're talking about you have just embarked on something like consent notice. But you're talking about grievance redressal. You're talking about, using your existing phone banking systems, etc., to understand what is privacy all about. And when the floodgates open, honestly, to the entire population as such, because honestly, your customers today do not understand the difference between a incident or a breach about privacy. Everything, anything and everything will come knocking at the DPO's door, because that is the email ID that you will be publishing as a part of your notice artifact. So my learnings this far has been like, it's going to be a very, very long road ahead. 18 months is not enough time, but yes, as the government has already mentioned, at least start with it. You're not expected to be perfect. Perfection will happen, as you move forward, 1 step at a time. But yeah, what I have experienced in the last 2 years has been like 3 steps forward, 1 step back at each juncture. Yeah.
We'll now move to few audience questions, and I'm just going to pick a few, and we promise you that we'll try and get back to all of these later. We've got 10 minutes. So, Supratim, I'm going to start with you. There's this lot of questions around consent manager. I know you alluded to it when you were explaining the rules. So maybe let's you say, if you forget you are a lawyer for a second, right, and just maybe educated all of us in plain English, this consent manager, which I know the provision in the law, etc. Uh, just in simple English, what is their role? How do they interact with data fiduciaries? Could you just clarify it for all of us?
Yeah, so maybe I will take you a little back to my journey across the country with Justice Sri Krishna, and I managed to attend almost every single consultation meet that had happened. And during that, we realized one thing very clearly, that consent is one of the worst grounds of processing personal data, especially for a country like India with large illiterate population, people speaking varied languages, and even the most educated person is reading nothing. They're just simply pressing I accept, I agree, and just moving ahead. And therefore, there were some solutions required. I think in Delhi and Bangalore and Hyderabad sessions of the consultation, some good techies had come and they had presented very nice, solutions. There were solutions, for example, like A triple plus rated organization means very good organization. You freely give data, no problem, etc. So just like your financial instruments, let's rank organizations. All those got scrapped. Finally, this one struck a chord, which is consent manager. And good that we are discussing, because I am still observing there's quite a bit of confusion in the market. Consent manager, in very crude terms, is I, as an individual, if I am giving a power of attorney of sorts to an independent third-party service provider and stating that, listen, I'm okay to give my consent for ABC, not for XYZ, wherever I'm going, please take care of it. Okay. And that particular entity then takes care of it properly. Okay. Rather than you trying to understand jargons, etc. All of those. Now, there are a lot of technicalities and legalities around this. Is it interoperable, data blind, all of those things. I'm not getting into that. But very simply put, it is not per se something that the data fiduciary has to do, because many people are confusing it with their own consent management system. I can always have my dashboard that if I'm a large conglomerate, this is my dashboard. Please come, put in your request. You will get a ticket number. It will get resolved. The law is not stopping you to do that. Okay. Consent manager is completely independent, third party provider who's there for the individual per se. Okay. Is in fiduciary duty with the individual, will take care of the wishes of the person. So please keep that in mind. I have found weird questions like, we need not do anything. Government will someday come up with a consent manager and that will take care of everything. This is a question I just heard in another webinar. So I was shocked when I got that question. I realized that it is good that we dissect it and explain it threadbare to every person possible.
Yeah. I think the maybe the more crude way I explain Supratim is to say that's like the policy bazaar or the clear trip for your flight bookings, but the airline has to still do its own thing and all of that, right? So maybe you can borrow that from me while I borrow a lot from you this time. Anyways, maybe one or two more questions, and maybe this time to you, Shubhosree, perhaps. Is as a bank, you obviously offer your own. Obviously, we spoke about processes and all of that, right? But you offer your own products. At times, you offer other parties' products, right? Mutual fund and an insurance policy, right? And I know this is a pretty pet topic as well. But how do you think about you acquired a customer or you've sold another organization product to your customer? Let's take an insurance policy or a mutual fund. So then, are you joint data fiduciaries?
I'm a
You know,
processor. We are very, very clear. If it depends on who onboarded the customer. So, classic case, while not retail, custody. Who has onboarded the customer? I could be a custodian of many documents, I could be custodian of many deals, but I'm a custodian, I'm a processor, right? Similarly, and I will have KYC information of my custody clients, but I'm a processor. Similarly, when it comes to a distribution of another bank's or another even joint venture partners, another entities, maybe within the HSBC family, another legal entity who has underwritten an insurance, which I am distributing as a bank. Again, I would be a processor. It's that entity who onboarded the customer who's a data fiduciary. This principles maybe because we are also GDPR and not just GDPR, CCPA, GDPR, P1PA compliant. We are managed by 36 regulators across the world. Some of these principles are ingrained, at least within organizations like us.
got it. Maybe two more and we'll close, guaranteed. Deepti, to you very quickly, I know you, and I'm asking you this because you talked about it, you've got maybe hundreds of thousands of data processors you work with, right? So, and I think as we spoke, it's just not enough to tighten contracts. You have to do some oversight over them. So how are you thinking about that?
So we're trying to tweak. So obviously we have our vendor risk management in place, which ideally would scope in high, medium, low risk vendors based on the activity that they performed. But leveraging the same model but tweaking it in terms of also now looking at high, medium, low risk vendors based on the PIIs shared with them, and also segregating the PIIs, because obviously DPDPA does not have that classification of SPDI and PII. So doing our own assessment as to whether a KYC parameter is more critical in comparison to maybe a date of birth, and then seeing that which vendor and which are the vendors who actually have access to the more critical. So slicing and dicing and categorizing my PIIs. Number one, the volumes of data probably processed by that particular vendor. So doing a high, medium, low risk categorization there, and then performing an assessment, and obviously an ABC kind of an analysis at the frequency with which each vendor will be looked at. So that is the take there.
Got it. Final question to you, Supratim. Difference between SDF, DF, when is that expected? Any pointers? And I
No,
kept the sort of best question for the last.
No, I think so. This is a request I have personally made to the lawmakers and the authority that listen, these two things please come out as soon as possible. One is significant data fiduciary, who all are these players? Because if someone is running at 100, they will have to start running at 200, right? It cannot happen overnight. And the second thing is the negative list of jurisdictions. Data architecture changing is not that easy as maybe the government is thinking. So it will take a lot of time. Of course, the idea was never to have a long list of negative jurisdictions, but with the present trade tensions, things have become a little murkier. When we started drafting, I had asked one of the draftsmen that, how will you come out with a list of negative jurisdictions? It will look so bad, etc. And they said that, listen, we have done this for FDI, right? We will use some smart language like countries which have got common land boundaries with India. But like I said, with new trade tensions right now, let's see where this list stands. Back to you.
Okay. Thank you. And I think we are dot on time. I want to thank all the panelists again. Appreciate the candor and the, very practical sort of experience sharing. It was a privilege to be on this call, and of course, a privilege to continue to collaborate with each of you. Thank all the audience for joining us today and for the questions. I know we couldn't cover all of them, but we promise we will get back with as many as we can, and we'll keep this dialogue going as IDfy, and I'm sure we'll continue to interact. But once again, thank you, Supratim, thank you, Shubhosree, thank you, Deepti. It was a real privilege to have this conversation.
Thank you.
Thank you.
Take care. Bye-bye.
Thank you. See you. Bye.